Guys, this is Cave. It is Monday, March 8th. Again, I am here with Roseville grad from 2008, Nick Pouladian. Nick is an attorney for the Legal Rights Center in Minneapolis. Welcome back, Nick.
Hey, James. Thanks for having me.
Of course. Thank you. So today, that third degree charge that we talked about in the last episode kind of threw a monkey wrench in things. Can you explain what happened today with Judge Cahill and this third degree murder charge in the courts?
Yeah, absolutely. Monkey wrench is probably the best way to put it. So where we left off was on Friday. The Court of Appeals sent that contested issue about third degree back to Judge Cahill to say, hey, Judge, you need to reconsider this issue. The reasoning you initially gave was incorrect. So that was the first thing on the docket addressed this morning. And it's kind of a big deal, right? You're trying to figure out, hey, what is a charge we're going to be going forward with or not going forward? So the parties agreed that because it's still in the appeals process, Judge Cahill can't address it one way or the other at this point. Really simply put, it's out of his hands as of right now.
Okay.
So the question was, with that being out of his hands, can the parties go forward? Can you continue the trial with what they've currently got? And that's where you saw a split between the two parties. The state and the defense both said, you know what, we're ready to go to trial. We can continue with trial, but yet the prosecutor is saying, Judge, we want us to stop everything until we figure out, until the Court of Appeals or the Supreme Court figures out this third degree murder issue. We don't want to start the trial with that hanging in limbo.
So how would that change maybe the prosecutor's strategy moving forward, the third degree murder charge or not? Why would they want to just stop? In fact, they stopped the trial, or they're waiting for the decision, but they stopped the jury selection as well. How will that change the strategy moving forward for the prosecution either way?
Yeah, so I think from the prosecution standpoint and what Matt Frank, the lead prosecutor with the Attorney General's office, outlined today was that they want to go into this trial having everything teed up, queued up, and set up without having to worry about any possible appellate mess afterwards, right? And one of the big thing there is that when the jury is impaneled and sworn in, jeopardy attaches. We have this thing called double jeopardy, meaning we can't just continue trying people again and again and again for charges based on the same incident, right? The big picture is that the state is supposed to bring all of the possible charges in one trial and not say, okay, we tried you for second degree, now we're going to try third degree in another trial. That's not what we want in the court system.
Okay.
So the state is trying to keep it very simple and just say, hey, we want everything figured out up front. We don't want to worry about, losing an appeal, having to figure out, do we need to go back and try this again? Can we try it again? They want everything up front. The defense was ready to go and just saying, hey, Judge, look, we can go forward as is. And in terms of, strategy or witnesses, the nature of the charge isn't something super technical. So from my outside perspective, and I'm not on the case, so I haven't seen the evidence. I'm not prepping with them or privy to their inner mindset, but they have the reasons for saying, hey, maybe we need more time. I don't know if there's an additional expert. They have potentially up to 400 witnesses that we'll talk about.
Yeah.
And I don't know if there's one that's going to really be hinging on the charge being there or not being there.
Okay, thank you. And so do you have any idea like when the courts will rule on this? I mean, I assume this is going to go to the Minnesota Supreme Court. Are we talking days? Are we talking weeks? What are we talking here potentially?
Yeah, so the immediate issue is the state today. Judge Cahill said, I'm going to continue forward, right? We're going to go forward with the second degree unintentional murder, and we're going to go forward with the second degree manslaughter. I can't touch the third degree, but we're going to go forward with everything else unless the appellate court tells me to stop, right?
Okay.
What the state did in response is they filed what's called a writ of prohibition. And that is essentially an emergency order up to the Court of Appeals to say, hey, folks, the district court is doing something wrong and detrimental, and we need you to address this right now and put a stop to it, right? So the state, and again, this is all very respectful. I mean, if you watch it, Judge Cahill even sort of offered that up and said, Mr. Prosecutor, here's what I'm doing. I'm assuming you'll file this motion, which is fine. So that there's no animosity there. So So the prosecutors filed it, and they're asking the Court of Appeals to tell Judge Cahill to stop, right? Or at least, if they don't say stop, give some definitive guidance, because everyone right now is sort of holding their breath with 1 foot in, 1 foot out.
Yeah.
Hopefully we have an answer tomorrow morning or tomorrow afternoon, because obviously there's a whole heck of a lot riding preparation from the parties, the cities. I mean, just the humanity and the human hurt and everything involved with this is sort of waiting with bated breath at this point.
So will jury selection continue tomorrow, or are they waiting? I guess they'll continue.
Yeah, it will. Judge Cahill has said, we're gonna chug forward until the Court of Appeal says no. So they're scheduled to begin jury selection second thing in the morning.
Okay, so jury selection was put on pause today. It will restart tomorrow, as you just told us. Both sides this afternoon discussed a couple things. They discussed sequestering the witnesses. Can you tell us what a sequester is and why you'd sequester a witness?
Yeah.
Or witnesses. The 350 to 400 possible witnesses.
They're going to need a bunch more rooms.
Yeah.
So sequestering a witness is essentially saying that witnesses who have not yet testified cannot sit in the courtroom and hear other witnesses' testimonies.
Why is that? Why is that?
Because we don't want witnesses coordinating or changing their testimony based on what they're hearing from somebody else who is currently testifying. So, if there's an issue that you and I are both witnesses to something, they're going to say, hey, Nick, you need to sit out in the hallway while James is testifying, because we want you, when it's your turn, to testify only to your personal knowledge, and we don't want you to sort of be influenced by James's testimony, and we definitely don't want you to coordinate your testimony with James, right?
Okay.
If we're talking about seeing two different things, but I say, oh, you know what? I forgot about that, or hey, James said this way and that's helpful to us, I'm going to say the same thing. We don't want that. We want folks coming in uncontaminated, so to speak.
Okay.
A difference where that comes in is with expert witnesses. Typically, experts are allowed to listen to other experts testify. So if you have an expert witness and I have an expert witness, our experts can listen to each other in order to try to sort of contest or combat those competing opinions.
Okay, thank you. Speaking of sequestering, is it just a given that the jury, once selected, will be sequestered for a trial like this type?
I wouldn't be surprised if it did in this case. So typically, jurors are they're kept together the whole time during a trial, but they're allowed to sort of have their phones. They're allowed to live their lives. They're directed by the judge not to look at social media. Don't look at the news. For most cases, it's not an issue. Most cases are, sort of just go unnoticed in everybody's day-to-day lives. In this one, you can't turn a corner or open your phone without reading something about it. And obviously, potential safety risks, worrying about jurors being threatened, persuaded, influenced one way or another. So I could for example, we're not going to know these folks' names and we're not going to see their faces on TV. So I think the court could very well decide to say, hey, jury, we are sort of going to black you out completely. I'm not just going to tell you not to talk about the case and send you on your way. We're really going to lock it down and keep it in here.
Does the jury pool have an idea, do you think, of what trial they're being questioned for?
I would suppose they have a hunch.
You're not explicitly told, though, at this point.
I don't know. Typically, they're not. Typically, they fill out a general questionnaire, and then they're sort of brought in, and then they learn about it as they go. So I would assume it's the same. That's a good question, but my hunch is that they probably don't know the specific case, at least explicitly.
Okay. One other thing that the attorneys and the judge, I'm assuming, discussed this afternoon was bringing up, I think you called it 404B, bringing up past behaviors from George Floyd and also Derek Chauvin. What is 404B, and can the attorneys do that? Bring up past incidents from both, or either the defense or the prosecution?
Yeah, the short answer is potentially.
Okay.
So the general principle that we have in our court system is that we want to judge people or determine what did or didn't happen based on any specific instance, and only the instance that's before the court, right? What we don't want is to say, hey, this person did something similar, or this person did something in the past, so therefore they must have done it this time. If they've done it once before, they're definitely going to have done it again. We don't want that. We want everything judged on its merits and only that immediate issue. Spriegel evidence is bringing up other potential prior bad acts or other instances that could be prejudicial, but they have to have a purpose other than saying it happened before, so it happened again. We call that propensity evidence. So in the case of the 404B issue today, talking about George Floyd's past instance from May 2019, the defense sort of pitched a spiel to say, Judge, there was a prior incident where George Floyd was allegedly or was determined to be on drugs, encountered police, fought with police, and kind of had a similar scuffle with them that happened, in this case. And we want to bring that in to show that the method that the defense tried to use was called a modus operandi, saying sort of a way of acting in a certain specific situation, right? On its face, that sort of is just propensity evidence, and that's sort of what the prosecutor responded with to say, hey, and the judge questioned him on this to say, well, it sounds to me like you're just trying to bring in evidence that he's used drugs in the past. What does that have to do with the elements of this case? And it could have been a different scenario where if Derek Chauvin was involved in that prior incident,
okay,
then it could have been a scenario where they could try to argue that, hey, Derek Chauvin is familiar with George Floyd. He was involved in this prior incident with him. He knew that George Floyd used drugs, and he knew that he would resist and fight arrests. So therefore, he knew that this level of force was necessary and appropriate, right? That could go to knowledge, perhaps. That would be the argument that they could try to make. But here, the judge said, well, there's really no connection between Derek Chauvin. There's no evidence that Derek Chauvin knew about that prior incident or was part of it. So at this point, Judge Cahill said that's out. That can't come in because there's no valid reason for it to come in at this point. And I don't anticipate that there will be a valid reason for it to come in.
Couple real quick. Let's bang out these questions right here. Who's in the courtroom? Who will be in the courtroom when this this trial starts?
So it's going to be, I'd have to check the exact numbers. It's listed in Judge Cahill's, one of his orders. Obviously, it's the attorneys, it's Derek Chauvin, it's the jurors, court reporters, court clerks. I think there is one family member from each side permitted, and it's not limited to any one specific family member. They can rotate who that is, but it's just one from George Floyd's family and one from Derek Chauvin's family at a time. And then Court TV, you can watch and live stream everything on Court TV. They actually have cameras in the courtroom. And then I think one or two media folks, but it's very limited beyond that. And the Hennepin County Sheriff's Office has a list every day, and you have to have credentials when you can come in. And they've actually cleared out the entire government center. Usually there are the places hustling and bustling with judges, with lawyers, with litigants. It's all shut down right now, except for the folks involved in the Derek Chauvin trial.
Okay, and why is that? Is that COVID related? Is that the scrutiny and the significance of this trial? Why would the government center be cleared out?
It is definitely the scrutiny of the trial, and I think fear, merited or not, of folks in the government who just are afraid of sort of the explosiveness of the situation.
Okay.
So we've had trials going on with COVID where they haven't cleared it out, they haven't shut it down. This is the only trial they're doing that for. And we actually have suburban courthouses in Brookdale and Ridgedale that we are also not utilizing those. Okay. Even though we could be. It's not downtown. There's no sign of protest or anything out there. So it's definitely due to the case. You've seen the barbed wire, you've seen the razor wire. The National Guard is out. So from the powers that be in the city, from their perspective, they're doing everything they can to prevent what they view as being a ticking time bomb.
So I know Derek Chauvin is out on bail, which I think is probably controversial in and of itself. But regardless, he showed up today. What safety measures are in place for him or his attorney, or the other, the prosecuting attorneys for that matter? What kind of security is involved in this? Well, the key players in this trial.
Yeah, good question. So, in terms of the day-to-day business hours, it's the Hennepin County Sheriff's Office. So there's like one way in and one way out of the government center. The deputies are checking IDs. They're looking at a list of people. If there are guns and Humvees and everything everywhere. Outside of that, I don't know. I remember when, everything sort of took off last May. There were, I don't know, a few hundred cops guarding Derek Chauvin's house. I don't know what authority they had to do that, and I don't know who's paying for it. So I don't know if he has, friends who are police officers. I don't know if there's some authority for folks who are part of a high-profile case who are entitled to city protection. I have no idea. I'm
Okay.
actually really curious. So if anybody knows, and I'm going to look into that because I would like to know.
Great. What else should we know? Last thing, what else should we know moving forward here? What are we looking for, or what are we waiting for, other than the third-degree murder charge appeal, etc.? What are we looking for here, or what's next?
Yeah, that'll sort of be the big thing, I think, and hopefully we'll find out tomorrow of, is the trial going to be happening now, or are we going to have to wait a little bit?
Okay.
Assuming it goes forward, we're going to start seeing jury selection. The attorneys did stipulate to striking 16 of the initial 50 potential jurors for cause. So the potential jury pool's already been whittled down to 34. So Judge Cahill is going to try to get through the rest. I think he said 7 in the morning and 7 in the afternoon to see if they can kind of get moving on that. So jury selection will be interesting. I would say folks go through and check out the jury questionnaire, see what kind of questions are in there. And I think that'll, assuming jury selection will take up a significant amount of time. So that'll be interesting to watch. I think especially knowing that we're not going to know who these people are, and we're not going to have seen their questionnaire. We're going to be really relying on the attorneys to glean what these folks answered and if what they answered was controversial or not. So it'll be a great tutorial in jury selection. I really encourage folks to watch it and check it out. Aside from that, we'll have to just wait and see tomorrow or the next day from the Court of Appeals.
Great. Thank you again for the summary and all the information. I think we're smarter because what you're highlighting, and I'll see you next time.
Sounds good, James. Thanks so much.
Thanks, Nick.
Take care.